So good morning. I'm happy to introduce Dr. Mark Hanson, who I have a little prepared bio to read here, but I want to tell you that I remember Mark better than he remembers me from his time at the Missoula Demonstration Project. He led that effort here, which was a nice federally funded important effort around death and dying in Missoula. I remember him because I applied for that job and he got it and I didn't. But he was much more well suited and did a really kind of phenomenal job from what I hear. So so Dr. Hanson is a lecturer in liberal studies and philosophy at the University of Montana, and he also teaches in the health professions program at Missoula College. He's on the ethics committee at St. Patrick's Hospital, and his his educational background is he has a doctorate in ethics and religious studies from the University of Virginia, and is a graduate of St. Olaf College for his undergraduate and Yale Divinity School for an MAR, Master of Arts and Religion. Before he came to Montana, he was Associate for Ethics and Society at the Hastings Center, which is a renowned bioethics research center in New York, I believe. And with that, happy to welcome Dr. Mark Hanson.
Okay. Thank you. It's great to be here, even if us academic types aren't used to speaking quite so early in the morning. But thank you, Robin, and thanks to the Institute of Health and Humanities for promoting this, and I'm happy that there's an ethics month as part of these medical center conferences. Is the volume okay? Can everybody hear me? Great. Thanks, Larry. So my title is clearly in front of you, but I know that there are others who have been part of this series who have talked about advanced directives and advanced care planning and some of the efforts that are going on here at St. Pat's, and they have done that probably much better than I would. What I wanted to do today, what my agenda is really, is to talk about, or just maybe try to share with you some insight on what do medical ethicists, what do philosophers talk about when they talk about advanced directives and proxy decision making. Making decisions on behalf of people who lack decision making capacity, or whom we call incompetent, is an everyday feature in a hospital, and is a difficult situation of judgment for medical professionals and for the family members and loved ones who are responsible for making sometimes agonizing decisions about whether to continue life-sustaining treatment, for example. And of course, medical ethicists, philosophers, lawyers, so on, like to think about, kind of on a deeper level, what are some of the issues that are raised when we talk about making decisions on behalf of other people who can't make those decisions. And so what I want to do today is kind of cover some of that terrain. At the end, I'll share some of my thoughts as I have time, but I'm not really going to, make an argument about it. I don't really want to. I'm not here certainly as much as ethicists like to kind of problematize and point out, the difficulties and nuances of some of these everyday decisions. I'm not also meaning to discourage the use of advanced directives or advanced care planning. Far from it. I think it's very important. But perhaps there are some lessons here in terms of how professionals and patients and their family members can be more thoughtful about what it is to make these kinds of decisions. So get started here. First, I think it's important to remind ourselves the ethical foundations really for patient decision making that really ground our care for, first of all, with competent patients. Again, with competent patients, I mean those who have, that's competent, incompetent is sort of the shorthand I'll use for those who have decision-making capacity relative to the decisions that need to be made. And this right of the patient to call the shots, so to speak, historically, one can find rooted in such now well-known decisions as Schlellendorf versus Society of New York Hospital from 1914, which said that every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his consent commits an assault for which he is liable in damages. This is true except in cases of emergency where the patient is unconscious and where it is necessary to operate before consent can be obtained. So informed consent really is one of those foundational ideas. I know, I believe there was a talk on this that I had to miss during spring break on informed consent by my colleague Stuart Justman. But it's really a foundational principle for healthcare and rooted in the principle of autonomy. And autonomy, defined here in one of the better-known medical ethics textbooks by Beecham and Childress, is respect for a person's capacity to choose his or her own vision of the good life and act accordingly. So autonomy is one of those main ethical principles. If you look at that text, Principles of Biomedical Ethics, you have autonomy, and then non-maleficence, do no harm, beneficence, provide benefits, justice. And autonomy almost has become the, dare I say, Trump principle. Can't use that word anymore without invoking something else. Has become the, almost the primary principle, right? I mean, respect for autonomy, even if they don't want, even if the decision that people makes doesn't seem to be in their own best interest, we still think people ought to have the right to make that choice. So, and so autonomy really is a primary value, and one of the questions that I'm going to raise is how do we talk about respecting people's choices when they no longer have the capacity to choose, and can advanced directives really do that? Autonomy, rooted in the in our tradition, is deeply rooted, especially in the work of a 18th century philosopher Immanuel Kant, which really defined autonomy centrally as treating people as rational decision makers. That's how you respect a person, and that idea in philosophy and ethics and in our culture is deeply rooted. And somebody a bit more recent than that, named Alan Goldman, who wrote a book on professional ethics. By the way, the date references here are to a works cited page. If anyone's interested in the references, I don't know if they'll be able to get those, but at any rate, Goldman, in talking about autonomy, talked about how individuals are really the best judges of their own interests. That is what are they most interested in? That's why we ask people. People's values and interests differ. And we value self-determination. We value, freedom. We value and we think freedom is necessary for people to develop and to be individually who they are. So that's the kind of ethical foundation that we use in looking at competent patients. And so the question is, okay, given those values, how do we think now about decision-making on behalf of the incompetent patients? So I broke down incompetent patients here for the purposes of this talk into a couple of categories. You have incompetent patients, or those lacking capacity, who have never had capacity, children, for example, and those who have been permanently or always severely mentally disabled. Then you have patients who are incompetent now but who were previously competent. And among those, for the purposes again of this talk, you have those who might have made some previous expression of wishes about what they might want when they are not able to make decisions for themselves. And then there are those who have not made any treatment-related values. So you have to make decisions on behalf of people who may not have said anything about what they would want. And so mostly in the ethics literature, you see what are called standards of proxy decision-making. I'll use the phrase proxy decision-making here just as my shorthand. It's a common one in the literature. It just refers to the proxy is the person who makes the decision on behalf of others. Sometimes it's referred to as surrogate decision-making, or those who in the state of Montana have what we call durable power of attorney for healthcare. So that's those are the surrogates are those with durable power of attorney for healthcare, are those who I'm including under the phrase proxy. And if you're making proxy decision, for proxy decision making, how do you do that? The literature stresses primarily the first 2 points on the slide here, which give us standards. And by standards, I mean sort of what are the kind of broad measuring, sticks that guide decision making, both legally and morally. These are established in the healthcare related law as well as in medical ethics. I'm really, today, this is a standard ethics disclaimer. Don't take any legal advice from me. I'm just going to be talking about what ethicists talk about. So the best interest standard, best interest standards, I'm going to say a little bit more about each of these as I go through. I'll define it and then talk about sort of what the issues are. But obviously that is kind of what it sounds like. You make a decision for somebody based on what you believe is in their best interests, usually medical best interests. Substituted judgment is a little bit misleading. It doesn't mean that the decision maker substitutes her judgment for the patient's judgment. It really means, as I'll elaborate, it really means deciding on behalf of the patients based on what they would want, if that is known. So, so best interest standard, substituted judgment standard, and then in the literature you see some other standards that are have been proposed. I'm going to talk about all of these as well. I'll define them as I come, but that's basically the subjects of what I'll be talking about here. So just a little bit more on the best interest standards, and I guess what I want to do is to talk about these first couple first, and then going to talk about a case a little bit, and then kind of come back to show what the issues are that these standards really raise for us. Best interest standards considered to be best applied for never competent patients, or if you have no previous expressions to draw upon from the patient. So in other words, if you don't know or cannot have known what a patient would want, then your standard is, okay, what's in this patient's best interest? According to ethicist Brock and Buchanan, that means acting so as to promote maximally the good of the individual. It's just, again, these are broad. You have to decide as a decision maker what that means. But that's essentially the idea. Ethically, it rests on ideas of non-maleficence, doing no harm, and beneficence. So you make the decision to say what possible courses of action are going to cause the least amount of harm and provide the greatest amount of benefit. And as it says here in the last point, you're balancing harms, risks, benefits to the patient. And I put that in italics up here. Because as you're looking at particular cases, and I find this when I teach classes too, and I give cases to students, that sometimes they'll say, well, but treating this person would be really expensive, and it would be really stressful for the parents, or really stressful for the caregivers. And in some ways that brings in the family's interests or other people's interests, not the best interest of the patient necessarily, unless that's affected by, the finances or something. So just a little qualification there. So best interest standard. When you have a patient about whom you know nothing about what they would want in that situation, how do you think about what decision to make? Substituted judgment, where a person, again, has previously expressed wishes, rests primarily, again, on this idea of autonomy. Right? What would they want? You're trying to respect their wishes in a particular situation when now they're not able to say for themselves. And this requires, the decision maker to make a decision that the incompetent person would have want were he competent. So the proxy decision maker is drawing on statements, values, actions, or even advanced directive, living will type expressions to what we might call extend the patient's previous autonomy into their current incompetent state. And just to kind of signal, that's one of the sort of key issues I think that philosophers puzzle about. To what extent does it make sense about extending autonomy of somebody who was a decision maker into a time when they're no longer a decision maker? That's just one of the issues raised by substituted judgment. So a couple other points just to consider about substituted judgment. This comes from a ruling of the Conroy Court, which was in the matter of Conroy from the New Jersey Supreme Court ruling of 1985, which was about essentially a 85-year-old bedridden, severely demented, a person with severe dementia, a woman. And in considering sort of the decisions around her, I won't get into the case, the court did, sort of a practical matter, come up with some criteria to think about in terms of considering a person's previous intent. So somebody makes statements about what they would want if they were incapacitated and in the hospital and needed treatment. What kind of criteria would you think about as to whether those expressions are valid? First, and the court came up with, I thought, a nice list. Remoteness, in other words, how long ago did they make those expressions? You're talking about an 85-year-old woman, but she talked about what she would have wanted when she was 25. What you want when you're 25 is different than what you want usually when you're older. So maybe if it's been a long time ago, there might be a little greater reason to have pause about listening to what she wanted. Consistency. If a person says one thing 1 year and 2 years, maybe they say, oh, I want everything done for me if I'm ever in that situation. And then one day they walk by the television set and they're talking about the Terry Schiavo case on TV, and then they say, oh, I would never want that. Then, well, there's some inconsistency maybe in what they've talked about. Thoughtfulness. To what extent did the person's expressions of what they want really express a kind of thoughtful consideration of it? Or to what extent was it an off-the-cuff remark in response to hearing about somebody in a hospital like that? Maturity of the person at the time of statement, sort of talked about that. To what extent, maybe not just maturity in terms of, were they 14 years old versus 24-year-old, but had they really come to kind of a more mature understanding of their life and what their values are and what they were, what they really want for themselves. And then specificity. People will say things like, oh, I don't want to be connected up to machines. I don't want any, I don't want to be on, I don't want heroic measures or extraordinary measures, these kinds of broad terms. Well, does that extend to artificial nutrition and hydration, for example? Does that extend to antibiotics if you have pneumonia and you're in a severely, brain damaged state, something like that? Okay, some criteria there. Advanced directives, I assume most of you know what they are, but again, advanced directives are this more formal way by which a person can make their wishes known. Comes in several forms, and some of which are a combination. Living will is obviously when you, actually give some specific statements of content about what you would want in a situation of incapacity. Designation of proxy without further direction, that's just saying, I'm just going to let my, spouse, significant other, partner, mother, father decide for me. They know me best. I might trust their judgment. I'm just going to let them evaluate it and judge it. You could have a combination of above, and we could just sort of, maybe I'll bank out of here for a second and just quickly. I think many of you are familiar with the My Choices form, which I'm happy to say the Missoula Demonstration Project had a hand in developing and getting into the Montana End of Life Registry. And this form is for Montana. You can see it's available at the website, Department of Justice End of Life documents. And here there is a, I got to do it this way. There's a living will section. where you can indicate what you want, express your wishes by checking boxes or attaching additional documents. Then you have the chronic, those for who are not terminally ill, chronic illness and serious disability aspect of the form. Then there's the healthcare durable power of attorney, so the designation of a proxy, primary representative, alternative representative, and so on. So this, and then any special directions that you may want in terms of just other directives you can see here. Not related to treatment as such, but perhaps after death. Okay, so so that's, you know, I just wanted to show you what's available here. There we are. And then, of course, there's something called POLSTs, Physician Orders for Life-Sustaining Treatment, which is for people who are maybe not in the hospital, who are maybe at home or in other settings. And these advance directives, of course, are invoked when a person loses decision-making capacity. So that means if somebody regains decision-making capacity, then they regain the authority to make the decisions on the spot, right? And the proxy, if there was one, would not be able to continue to make those decisions. And also includes, I think, important to note ethically, the possibility of changing your mind. You can, when you regain competency, you can, you know, change it. Obviously, you can change it at any particular point that you are competent to do so. So the advance directive legislation, starting, a lot of this got its impetus in this famous case of Karen Ann Quinlan in 1976, the young woman who went into a persistent vegetative state as a result of combination alcohol and drugs. Not an uncommon situation, unfortunately. And this court ruling did go a long way to begin to establish the right of people to refuse life-sustaining treatment and the right of proxy decision makers, including in this case your parents, to make the decision as they went to court to do to try to remove life-sustaining treatment from her. Well, a series of cases since then have certainly just bolstered that, you know, those particular rights of refusal and the rights of proxy decision makers, and limiting criminal liability, of course, for decisions that they may make on behalf of their loved ones. And here you can see, again, the link to the registry, end-of-life registry. The Montana statute, relevant statutes are also listed here. I won't pull that up right now. And then we had in 1990 something called the Patient Self-Determination Act, which was a way to, well, it was a federal act which gave really, I think, much greater opportunity for people to become aware of and to learn about advance directives, as they were now, any federal institution or institution receiving federal funds needed to offer advance directives as part of their, you know, as part of their care. So you see, not that it's mandated to have them, but that they need to be offered. And I think that's part of the admissions packet or admissions process when you check into a place like St. Pat's. Now, in terms of advance directives, obligations that physicians have, of course, and proxy decision makers are obligated to follow the directions given by the patient when the patient was competent. So if their advance directives, such as the My Choices form that we saw, contained any living will directives, then they would need to, the proxy would need to follow those. You can't have a living will that says, I don't want this, and then the proxy says, oh yes she does, doctor, please give it to her. That, you know, the living will portion of that advance directive is ethically and could be legally binding on the proxy as well as the health professional. Physicians therefore have what we might call a prima facie or a, you know, all things considered, you need to follow the proxy, you need to follow the advance directive, unless you would have sufficient grounds for challenging it. And what might those grounds be? Well, if the physician had any reasons to question the validity of the advance directive or of the statements, if there weren't any formal advance directive, maybe the report of some statements that were made by the physician or by the patient previously. So, if you have a patient who has been, let's say, often or mostly, mentally disabled or incompetent for most of their life, and they have an advance directive, you might say, well, was this really done under, by a person of sound mind? So you may have a reason like that, or maybe, some other reason. Maybe the proxy is not, as you've known him or her, doesn't seem to be acting in manners or have values that are consistent with the advance directive. Perhaps the advance directive could be, well, I think one of the, if you have one of the ethical tensions that I'm going to get into is, what if you have an advance directive that is obviously contrary to the current patient's medical best interests? That raises one of those ethical questions, right? They say they don't want something, but it seems medically it would be the right thing to do to give them something. Then, of course, that's where one of the decisions comes in, and we'll talk about that. Or if they make a request in their advance directive that would be contrary to law. If the advance directive says, if I'm in this particular place, please euthanize me, obviously you couldn't do that. Or offer assisted suicide or something like that. So in the end, I think, the thing about patient autonomy, of course, is we get, so used to stressing patient autonomy and the rights of patients to make their own decisions. And a lot of times the issue isn't, as just respecting what the patient wants or what the patient refuses, but sometimes what the patient may demand or may want that the physician doesn't want to provide, or believes that, for example, perhaps that it's medically futile to provide. And so then this raises, of course, another huge ethical question about futility and giving futile treatment. But certainly advance directives, just as in other demands that patients may make, don't obligate a physician to do whatever, the patient is demanding. And so physicians as moral agents, moral actors in particular cases, people with a moral conscience, are not obligated to simply violate their conscience or to act what they believe unethically simply because an advance directive or even a competent patient were to demand something they didn't think was ethically right. So advance directives, of course, have a number of advantages that I've mentioned some of these already. They promote patient autonomy to a greater degree. They help avoid unacceptable circumstances that a patient would consider to be harmful or wrongful, loss of pain or dignity that they don't desire. They can really lessen the burden on caregivers and healthcare providers by, absolving them of difficult decisions. So I didn't put any references on here, but I've certainly seen one. I've seen several of these kinds of reports of stress levels on caregivers. There was one essay in a nursing journal that was talking about the level of stress that family members have when they have to make decisions about life-sustaining treatment and they have no advanced, directives or just even comments to draw upon. It's considered in rankings amongst the most stressful things that decision makers have to do. And in fact, studies have also shown that in the absence of advanced directives, that decision makers may be more inclined to continue aggressive life-sustaining treatment than they would otherwise if their loved one had sort of given them the the direction to allow them to let go or to stop any life-sustaining treatment. Some particular difficulties with advanced directives. Again, I'm sorry I don't have a cite on this, but just through my reading and teaching over the years, uncertainty of medical condition and prognosis. So you may have a, question is this person terminally ill or not? What are their odds of recovery? What are their odds of recovering their competency? Is it possible that they could regain their decision-making capacity at a later time if we just continued with some treatment? What's their, or maybe there may be just even some uncertainty about what's going on, what their particular condition is. So if you have a lack of specificity in the advance directive, again, statements like, I don't want any heroic measures, isn't very specific. And regardless, oftentimes there can be a need for interpretation. The proxy decision maker may still have to interpret, as we'll see in the case I'm going to show here in a minute, what a particular statement might mean and whether it applies in this particular situation. There can be tensions between their stated wishes and their contemporaneous interests, and again, this is an issue I'm going to come back to. In other words, they may state, I would never want to live this way, but now they're in that situation and they actually seem kind of happy. They may not be competent, but they're not suffering. So their contemporaneous, you might say their current interests seem to be in tension with what they anticipated they were going to experience when they thought, oh, living with Alzheimer's is going to be this miserable existence, and maybe it isn't for them in that, at least at that moment. Timely access to advance directives. Of course, the end-of-life registry helps in Montana people, caregivers, to find them quickly. They're not locked in a safe deposit box somewhere when you need them. And ethicist Brock and Buchanan's report that an advance directive is less likely to elicit supportive family members than expressions of current interests. And this kind of goes back to the point, actually I should have put that up a little bit. Family members are going to be more responsive to how their family members are doing in the moment rather than what they said 5 years ago about what they would want. It's harder to say, oh, let's not treat her pneumonia and let her die when she's sitting there smiling at you, right? So that kind of idea. All right, so what I want to do, and I'm going to have to, I'm just looking at the time and what I want to cover, but I still want to do this to try to bring this alive. Too much text. I'm going to read this. I know it's maybe kind of small. This case example actually came from the Hastings Center report, and from 1998. The full title of this is called An Alert and Incompetent Self, the Irrelevance of Advance Directives. So the case is meant to now, I think, raise the issues that I wanted to address on advance directives and just, kind of see what you think about it. I'll just take a couple of minutes after I read it to maybe get your responses, and then I'll just finish out the hour here. So this is a case of a 73-year-old woman with a history of emphysema and manic depression. She was admitted to the hospital with shortness of breath. She was treated with steroids but developed progressive respiratory failure and psychosis. She was intubated and transferred to the intensive care unit where she was found to have a blood clot in her lung. She was treated with a blood-thinning agent and had a major blood episode. She remained confused, presumably because of oxygen deprivation, infection, and chemical imbalance, though the staff could not rule out permanent brain damage. She was transferred to the chronic ventilator floor, and with the consent of her primary care physician, a feeding tube was placed and a tracheostomy was performed for long-term ventilator support. The critical care team hoped to wean her from the ventilator. The neurology consultant believed the patient might be able to be weaned successfully from the ventilator, but that it would take months at best. The patient remained alert, confused but awake and alert. She interacted with staff and visitors and spent much of the day sitting up in a chair watching television. The psychiatrist who had followed her for manic depression found her cognitively impaired and incompetent for decision making. Although the patient was widowed and without children or other living relatives, two close friends who said they had known her for 50 years spoke on her behalf. They were not legally designated proxies, but held and had witnessed the patient's living will, which the patient had executed twice, most recently 5 years earlier. The will indicated that the patient did not want to be kept alive by life support technology if she had no, quote, reasonable expectation for recovery from extreme physical or mental disability, unquote. On the basis of their history with the patient in this will, the patient's friends and her primary care physician requested that she be removed from the ventilator. The critical care physician and nursing staff objected. The friends wrote a letter to the ethics committee explaining that this woman was an extremely independent-minded person who would have hated being kept alive in this dependent condition. The patient's primary care physician, who had known her for 7 years, supported this view. The critical care staff, however, was reluctant to have the tracheostomy tube removed because the patient appeared to be comfortable and gave no indication that she wished to be withdrawn from life support. When asked whether she would want to be removed from life support, she would indicate no. The patient's friends and primary care physician, however, believed she was too confused to understand the question. Citing the psychiatrist's report, they argued that she was incompetent to make this decision. The hospital ethics committee was consulted and eventually supported the critical care team's decision to defer withdrawal of life support while continuing to evaluate the patient's decision-making capacity and wishes. The committee members were influenced by the critical care physician's opinion that the patient was showing signs of improved cognitive function. They suggested that if the primary care physician remained committed to withdrawing life support immediately, he should arrange transfer of the patient to another hospital. The physician had the patient transferred to another hospital where a physician indicated willingness to comply with the wishes of the two friends. On the day of the transfer, the patient and the nursing staff cried. The patient was transferred to the other hospital. The ethics committee was consulted and the neurologic and psychiatric evaluations were ordered. The psychiatrist found the patient incompetent and the neurologist thought she had suffered permanent brain damage. The ventilator was removed and she died a week later. This case, the reason why I selected this case is that it's often the case that these, the kind of advanced dementia type cases really are the ones that challenge the notions of advanced directives, I think, the most. So maybe just with a pause here in my presentation, I could just see if any of you are interested in offering a little bit of feedback on any of these questions. And we'll have to keep this short, but just food for thought. Was the outcome of this case morally justifiable? Would anybody would anybody want to argue or suggest that well, actually, let's cut to the second question. I saw a few nods on that one. You know, what's the implications here about the advanced directive, or the advanced directive? I guess that's another way of putting the question. Was it ethically defensible to follow the advanced directive to remove support in this particular case? Does anybody have any thoughts about what issues are raised here? Any care to? Yeah.
How's that? Yeah, that's about as tough as it gets.
Yeah.
But I think those are bad questions. I don't think it's morally, a judgment one way or the other. They did the best they could, and the outcome kind of speaks for itself. What I don't like is that the first team just punted the problem. They didn't address it. They just transferred the patient to another hospital. Not that I wouldn't have done the same thing, but is that morally justified?
Yeah, I mean, they did take a position that they felt like more time should be given to the patient. And when I have my students discuss these as mock ethics committees in class, that's almost always what they come up with. Let's get a little more information. But then it does seem odd then if they think that's the ethically right thing to do, then they should stick to that and not just not just transfer her. But then that sort of brings me back to that sort of final question, which is, would either outcome have been unacceptable, morally prohibited? To remove it or not to remove it, would you have felt like the wrong thing was done in either case? And I think that's maybe what triggered your response. But Dr. Rance, did you? Mm-hmm.
If the original team had just stayed on board and the ethics committee said, let's give it a little more time, they could have given it a little more time, and it would have been the same outcome. I don't think there's any question about that. But
yeah, I agree. Anyone else just want to make a comment on any issues that are raised by the case?
that they lacked capacity.
Yeah.
What I've read in literature discussion about limited capacity, and I'd like to add, if the patient, instead of saying no, said something to the effect of, they're trying to murder me.
Yeah.
How does that change this situation?
Right. Yeah, I think it is important to note that capacity is not a yes or no thing. You would want to assess it relative to the particular decision being made, and it can also vary. At least, I don't know in this case, but in other cases as well. Good question. Yeah, Tim?
Another issue raised by this is the difference between consent and assent.
Okay.
Do we need the assent of an incapacitated patient to execute a decision that is made by a proxy or basically made based on their advance directive? And I think that's kind of interesting, especially when there's a tension as opposed to symmetry between those two.
Yeah, good point.
I'm interested in, maybe legally, and I don't know, who gets to be a proxy? I mean, in this case, there was no clear proxy identified. The hospital treatment team who had known the patient for a very short time during her critical illness got to be the proxy by default, and the people that had known her much longer, including a primary care physician, were not allowed to be the proxy. Is there any sort of legal or ethical ground there that you would consider?
Yeah. There usually is a hierarchy on, sometimes state law addresses this. When there is no advance directive or legally designated proxy, then there's usually it would usually fall to a spouse first, and then adult children or adult parents or siblings. There is a kind of way of doing that. In a particular situation like this, where there didn't seem to be any family members, then usually I think, someone can correct me if I'm wrong, that the physician is trying to rely on, whatever reports, one really has in terms of what one knows about this particular patient. But I don't know if anyone else, can have any more to add to that. It's one of the final points that I'll look at in terms of standards of proxy decision making was by this Conroy court, referred to the kind of limited objective standards, which is you assess the patient's best interests in combination with whatever you know about the patient. There's kind of that, trying to bring together as much information, both medically and ethically, that you have to make the best judgment. So it's not a full best interest, but it's best interest also based on, informed by what you know. And, women who knew her for 50 years and a physician who's known her for 7 years, could really help inform that decision. Okay. Just before we move on, the final question, even if one outcome is ethically better than another, is the choice of either treatment or non-treatment ultimately wrong? Again, a lot of times in ethics, as you said, this is a tough case. There's no formula for saying, oh, absolutely, this is always ethically, well, certain things are always ethically right and ethically wrong, but in tough cases, you're just trying to do the ethically better rather than the ethically worse. And I think I asked this question to my students, and they said, well, most of them said, well, I think there should, like the first ethics committee, let's get a little bit more information to assess this case. but it was the presence of what they did know about the patient's wishes. And, you know, there were certainly students of mine who said, she's got an advance directive. This is what she wants. This is extreme mental and physical disability. I think that definition applies here. That's how I would interpret it. And this is, you know, one should act according to what she said, sort of end of story. But in either case, I think there was a willingness to say, even if you preferred one outcome, it was not necessarily an immoral outcome, regardless of which committee. I think, you know, and the comments were right. The transfer, I think, really was in some ways part of the ethically interesting part of the case. But cases like this, where you have this question of, especially those who, you know, when you lose capacity, you may have some who lose capacity and it's going to be temporary. You have some who are going to lose it in a way that you know, is going to be progressive and even permanent. You have those who, like this woman in this case, you know, you ask her a question, she says no. You know, well, what does that really mean? Is there any level of awareness of what's going on here? And then, of course, you could have people in persistent vegetative states. Terry Schiavo, who's not going to be telling us anything. And then, of course, there are people make directives, as you saw in the My Choices form, about what they want after they die. And so following directions of, that are given by people who are no longer alive has all of these different possibilities have prompted ethicists and philosophers to ask the question, does substituted judgment, this deciding on behalf of others based on what they would have said, really make sense? Daniel Callahan, who was my former boss at the Hastings Center, wrote, how can someone in a rational way irrevocably, that's an important term, determine well in advance what they will want in a situation they have never experienced before? That's kind of the basic way to put it. Other questions raised, can your interests, and that is things that you say that you would want, survive dementia, permanent unconsciousness, or even death? Can we respect autonomy if there is no competent chooser anymore? That's kind of how we think about the basis of, ethical basis of informed consent is autonomy. And then those who are, you know, inclined sometimes raise identity questions. Is the severely demented person the same person as they were before? And if not, why should their previous wishes be respected? And, you know, on the one hand, I always kind of think, oh, this is, you know, this is philosophers' abstractions. You know, let's talk about identity. Are you really the same person you were 5 minutes ago, to say nothing about whatever, when you were a baby? But on the other hand, listen to the way people talk. And I remember this even from my own grandmother who had advanced dementia. You know, my sweet little grandmother in the nursing home in Brookings, South Dakota, what did she do at the end of her life? She took a swing at the nurses. And your first response to people is, that's not my grandma anymore. You know, that's not her, that's not who she was. She's not the same person. I mean, we do kind of think of people of having somehow fundamentally have their identities transformed by their conditions. So, but if this, you know, grandmother, despite her aggressiveness in that particular situation, were otherwise doing well and being happy, then should her previous wishes be respected if she's not the same person? You know, I think those are identity questions that in some ways are interesting philosophical questions, but I think can also be real questions for some people. The legal expert Sanford Kadish wrote in the California Law Review, you know, also said the effect of severe life-imperiling illnesses may well produce marked revision in the attitudes and values of the person. Think of people who are maybe not really severely compromised. What people thought they would want often turns out to be very different from what they do want. So you get people kind of breaking down in a couple different ways on this. I'm going to have to move through this pretty quickly, so I may skip over some points. But one of the classic positions is represented by a philosopher named Ronald Dworkin, who talks about critical interests versus experiential interests. And I think this kind of gets to the heart of it. Your critical interests are these are the things that, the kinds of, they represent your values and what you want. You have a critical interest in now you have a critical interest in not sitting, in a nursing home, completely unable to recognize anybody, incapable of relationship, drooling on yourself. That's your interest. You don't want your life to end that way. Experiential interests are, what is the person experiencing right now? If the person sitting in the nursing home is happy watching, The Price is Right and the parakeets in the cage, and seems to enjoy having her hair brushed and seeing people even if she doesn't know who they are, there's a sense of maybe not just suffering, but sometimes what are referred to as the pleasantly demented. Their experiential interests may come into conflict with their critical interests. Oh, I never want to live that way, they said 5 years ago. Well, Ronald Dworkin says a competent person's right to autonomy requires that his past decisions about how he is to be treated if he is to become demented be respected, even if they do not represent and even if they contradict the desires he has when we respect them, provided he did not change his mind while he was still in charge of his life. In other words, yes, respect the advance directive. As long as he didn't change it while he was competent, that's really what it means to respect persons. So he calls this a kind of integrity view of autonomy. We want people to let people lead their lives out of a distinctive sense of their own character, a sense of what is important to them. And I actually think this is a nice point, this last one. People also want their deaths, or maybe their end stage of life, not just their death, to express and confirm the values they believe most important to their lives. If who that person was a very independent person, the very idea of living in a very compromised, dependent state, it doesn't witness perhaps to who they really see themselves as who they are. And in all parts of their lives, even at the end, don't want to be sort of identified that way. And I think he's saying we have to respect that. Okay, so that's a kind of, yes, autonomy makes sense. I'm going to just skip over this. This is just another way of putting it. Investment interest versus welfare interests. Then there are those who says, well, no, substituted judgment really doesn't make sense. Rebecca Dresser, I think she's a law professor and bioethicist, said, the interests of demented patients might differ from those they had as competent persons. When people become demented and physically debilitated, what was once important to them is often forgotten, while physical and comfort and what we might view as low-level interactions with people and environments often become vitally significant. Okay? Now that's what's important to them, is just the visitor who stops by, interacting with nurses. That's what's really important now. And so if it's really changed that way, then don't make a decision based on an advance directive. Her response to Dworkin is that she says, as a matter of practice, people may have insufficient or mistaken information about the implications of their decisions. So when people make advance directives, do they really know what they might be in for? What is the quality of life of somebody, with the particular prognosis that they have? Dworkin's view leaves no room for a change of heart. We value that, and perhaps we should, even if they're less than competent or somewhat compromised. And I think if you go back to the case, again, the woman said no, she cried when she was taken away from the nursing home. Are those at all, obviously those are places where she's might be, especially when she cried, unhappy about something. So, would we say her experiential interests really are, she just is okay with where she is right now, so we should respect that. And maybe in some ways it represents, not a rational change of mind, but a certainly change of one's experience than from what one anticipated. Can we at some point consider the patient a new or different person? We talked about that. A disability perspective on dementia favors, I should say, experiential interest, which is to say, this raises another dimension of this. If you think about treatment of the disabled, the idea is that we should, ones who, of course, if you don't have decision-making competency, you treat them based on their experiential interests. Daniel Callahan also, with Rebecca Dresser, agrees, says rather than proxy decision-making standards, sorry, I skipped a slide here. We should be suspicious of earlier declarations to terminate life-sustaining treatment if the patient with dementia is doing well. Advanced directives are founded on the idea that one can change one's mind. Without an advanced directive, a demented person still can be said to have a self, that is, they have feelings, some even capacity for reason perhaps in some way. They can have relationships. They're not outside the community, human community, and therefore there should be a presumption to treat them. So he and Dresser would say the woman in this case, forget the advance, previous stated wishes. If she's, given this condition that she's in, one should go ahead and treat. Let's see, because I'm down to the last few minutes here, I'm going to just point out make a couple other points here. So those are kind of the two major, positions on substituted judgment. John Robertson also says it matters not that as a competent person, the individual would not want to be maintained in a debilitated or disabled state. We should focus on the incompetent patient's needs and interests as they are now exist and not view them as retaining interests and values which, because of their incompetency, no longer apply. So what they propose instead is what they call the current interest standard. It requires observers to evaluate from the incompetent patient's perspective indications of the patient's subjective state and ultimately to judge whether this state of existence is sufficiently good to justify further treatment of the patient. So you would look at the woman in the case that we talked about and said, just based on her subjective state right now, not her previous critical interests, but in other words, her experiential interests. What does that seem to suggest about whether we should continue to treat her or treat whatever conditions that come up? That's really what they would argue. And they say, when it comes to substituted judgment, sometimes family members are trying to report on what they said the patient would want. But they, I think, make an important point when they say sometimes that allows the subjectivity of what the family or the proxy decision maker wants can subtly or not so subtly sneak into those reports, right? So, a decision maker who has to decide, do I keep my wife on life support? Well, she said she didn't want to be on it this way, and she was opposed to lots of technological intervention, so no, she wouldn't. But does he have a kind of, does he have his own biases that are maybe informing his particular report? And I think that has to be, they're saying by taking a current interest approach, you're just looking at the patient now. What is the patient experiencing? What is in their best interest? I'm going to, so not just another possibility was what someone called, similar to the current interest, is the therapeutic standard. What's in the patient's best therapeutic interest serves their therapeutic interests in the limited but important sense of not being abusive or neglective of the patient's needs. And then the limited objective standard that I talked about before, trying to kind of make your best decision. And so I think I'm going to end it with that because time is up and I think I need to stick pretty firmly to that. There are other issues that, of course, I could have gotten into. Best interest standards as well, I think, raises some questions about how one evaluates best interests. Is it the reasonable person? Does that include sort of social interest? How much do you rely on particular individual preferences when you're, regardless of whether they made official statements or not? But so I think where I would just end up is, I was trying to think, okay, practically, what's the upshot here? I think to kind of be aware that whether you're evaluating best interests or whether you're trying to assess the validity or the statements of an advance directive in a case such as we looked at, or even if you're counseling people in advanced care planning, you know, just to be aware, you know, I mean, John Robertson said, not everyone, or was Dresser said, not everyone is Dworkin, you know, not everyone's thinking about making their advance directives with questions about their identity necessarily. But I think being aware of those kinds of ideas, that what a person might experience in an incompetent state, you know, to what extent, you know, should that be talked about? Or of course you may want to talk about that, but, you know, having people consider what their reasons are really behind their advance directive. What are they really, what values are they trying to promote? Is it their sense of self? Is it their sense of identity wanting to carry through? Is it a fear about what they might be facing when they lose their competency? You know, so I guess my goal really here, hope I've made some progress toward accomplishing that, is to really, in some sense, just suggest that it's not always quite as straightforward ethically, and those of you who work with patients know this, to simply say, well, get an advance directive and then we'll follow it. Moral decision making, as you probably all know, is in some ways as much an art as anything, and you're always just trying to make the best decision you can. And so I hope at least the presentation that I've given today helps us to think a little bit more deeply about some of the ways in which people will make decisions for other people, and the kinds of ethical and philosophical decisions that are raised there. And so with that, I am officially out of time. So I'll conclude there. I can be around a little bit afterwards if you want to have some discussion, but I guess that officially has to end our session. So I'll stop there, and thank you for your attention and your comments, and hope it's been helpful for you. So thank you.